a bit of strife over religious issues. And in the present context, the words that are being thrown in the public realm by political leadership of all kinds is Places of Worship Act, the doctrine of basic structure of the Constitution. People are talking about it, the TV anchors are talking about it, and there's a huge amount of speculation. So my first query, sir, to you is, in the present stage of discourse being projected at the public level, information or misinformation, how do you think we should be talking about these issues in the context of larger constitutional values?
Mr. Nanda, I had mentioned in my 2-minute speech what is public discourse. Public discourse is what it should not be. Places of Worship Act. Rightly or wrongly, the Supreme Court in the Ayodhya judgment had dealt with it. And though it was not directly an issue, had said it's a fine piece of legislation. There are challenges to that act pending in the Supreme Court. When the matter is pending in the court, the public discourse should be restrained. You should not preempt the court from deciding something. If you're not happy about the time within which the issue will be settled by the Supreme Court, there are ways and means of tackling it. But you don't go and get into a public debate on that. But then, as I said in that very brief speech, public discourse is all about what is convenient, not what is necessarily good. This is a problem.
Sorry.
Yes.
A small supplementary to this, sir. In today's context, the nature of public discourse, as we understand, is what the newspapers report, what the television channels report, what people talk among themselves. With the messages reaching out instantly, an incident happens in any one part of the country, it is available in video form all across the country. It is there in the newspapers. There's a pressure on everybody. The judiciary is also beginning to take, and writ petitions are being moved. At times within 8 hours of an event taking place or an event about to take place, say the Jahangirpuri demolition thing we talked about, the police allegedly planned to have an operation the next morning. By 10 o'clock, applications, writ petitions and all had moved. We are moving in a new technology where virtual hearings are possible. The Supreme Court may be flooded with such applications for interventions of various kinds from all over the country, a demolition in a part of Jaipur or in Cochin or whatever. So in this age of fast-moving technology, the expectations from the judiciary are high, from the parliament are high. So the traditional waiting time for the people, for instance, Ayodhya judgment took over 100 years. Do you think things need to speeden up to keep pace with the way society is changing?
See, with the advancement of technology, expectations run high. But don't forget, beyond technology or behind technology is the human face. The human face has remained the same. The technology and your expectations have put pressures on that human. Don't. He will make mistakes. Expectations are good and should be encouraged. But beyond a certain point, you have to understand that the decision eventually will come from the human mind, not from the technological advancement or from the machine. If you want a decision from the machine, have it. But if you want the mind to be applied judiciously, independently, you have to give the person concerned, namely the judge, a reasonable time.
Sir, in the final appeal that was heard by the Supreme Court on Ayodhya, you've mentioned in the book that while the judges had handled the pressure very well and the 5-judge bench was acting with a fair amount of coordination, and for on a rare kind of a manner, a 5-judge bench on such a matter could arrive at a consensus, whereas we've had on very important constitutional matters, whether it is the Keshwananda Bharati case or the Goloknath case earlier and so on, huge sharp divisions in the Supreme Court benches, 7-6, 6-5, etc., etc. Now, as part of this consensus judgment, you also stated towards, in your book, that you decided that this matter has to be resolved and you will keep yourself away from mental pressures of the impact for politics and other aspects. What was the process of decision-making in the mind to arrive at such an approach, both about the consensus and this attitude?
Mr. Nanda, those who belong to the legal fraternity would know that the longest case in India's judicial history is the Keshavananda Bharati case. That took about 66 odd days. And on a very lighter note, pardon me, it took 66 days and not more because the Chief Justice had to go abroad. He was retiring. So he was to visit 16 countries in 16 days. So he had to wind up the hearing. So that hearing concluded in 66 days. One very similar thing happened in the Ayodhya case. As the Chief Justice of India, I was due to visit Brazil, USA, Canada, Germany, Bali. Tickets were purchased, bookings were made. And my colleague said, Chief, you go, we'll manage. I said, no, I'll not go. The Ayodhya hearing was the second longest hearing. It went on for 44 days. And 44 days spread over about 4 months, 3.5 months. Keshavananda Bharati case, I'm sure Mr. Nanda would talk about it further, is the backbone of Indian judicial thinking, particularly in regard to relation between the executive and the legislature, the basic structure doctrine. The Keshavananda Bharati case says Parliament, even by a constitutional amendment, cannot change the basic structure of the Constitution. It's a restraint on Parliament. It went by a majority of 7-6. 7 judges said, Parliament can't do it. 6 judges said, Parliament can do it. 7-6. It was not really so. It was not really 7-6. But that's another story. Ayodhya was unanimous.
Sir, I'm so glad that you've mentioned the Keshwan.
No, one minute,
Sorry.
Mr. Nanda. I have not completed.
Okay.
You see, there is a very bad habit that I have built up. I'd like to speak. I have remained silent for 20 years. of my tenure.
Fair enough.
So, Mr. Nanda, unless you are in a hurry, or if the audience is not in a hurry.
All the time, sir, all the time.
I have the time. I am due to take a flight back at about 9 o'clock. Now, Ayodhya was unanimous. It was not only unanimous, it was anonymous. Who wrote the judgment? Keshavananda Bharati was 1973. Ayodhya came 45 years later. Judges have become different. Mr. Nanda talked about pressures. Mr. Nanda talked about technological development. But look at the cool way. In 1973, 13 judges quarreled. And that quarrel is in this book. The book is the untold story of struggle for supremacy by Supreme Court and Parliament. This book is not in the market. I don't know why. The author is T.R. Andhar Arjuna. He was the Solicitor General. This book is not in the market. I don't know why. Now, this book is something that I would request all of you to read. Then one would get to know what happens in court. You know, Mr. Nanda, be patient. Be patient. The official version is 7:6. Chief Justice Sikri, I am not saying it, the book says it. Chief Justice Sikri, at the time of delivery of the judgment, on his last working day, pulled out a paper from his pocket and said, views by the majority. And one of the views by the majority is Parliament can't change the basic structure of the Constitution. This was not the views of the majority. The basic structure was by one judge, Justice Khanna. Chief Justice Sikri pulled out a piece of paper, typed views of the majority. The first view is Parliament can't change the basic structure of the Constitution. And 8 judges signed it. Their judgments say differently, they signed the majority view differently. How do you explain this? Ayodhya was unanimous and Ayodhya was anonymous. There was no friction. How that unanimity came? Don't ask me. Ask the other judges. Why the judgment does not have the name of a judge who authored it? I don't know. Everybody said, no, we will not put our names here. Why? I don't know. Yes, Mr. Nanda. It appears
Anonymity enables freedom. You can say what you want. It also enables you to escape responsibility for what you may do wrong. That is the tragedy. Now, these kind of judgments, any judgment more than a 5-judge bench is an important judgment. Now, coming to the Keshavananda Bharati case, sir, I'm so glad that you used the word, the Keshavananda Bharati is the backbone of our, broadly, the legal architecture, constitutional architecture as we have today. Now, ladies and gentlemen, the problem is, now a lot of people move from journalism to law, a lot of people move into the field of law, and there are a lot of us lay citizens. Law impacts society. हम लोग नागरिकों की तरह उसके बारे में चर्चा करते हैं, बात करते हैं, and when the judgments are delivered, they are delivered in very legalese, per incuriam, obiter dicta, and so on, which a layperson doesn't understand. And then what happens, sir, is there is misinformation in the society. Now, the issues that are debated in the Keshavananda Bharati judgment, as Gogoi Sahib has also said, are very crucial. Impact the question of fundamental rights, The Supreme Court took a position that fundamental rights are a part of the basic structure, they cannot be altered. And on the two sides were ranged. The people ironically talking about defense of fundamental rights in that, where people owning big mutts also, property, right to property also, sir, indirectly flew in. Now, after the Keshavanand Bharati judgment, it defined the basic structure of the Constitution. The term basic structure, as a lot of people know, does not exist in the Constitution. We as school kids grew up learning that there are three aspects, the three pillars: the parliament, the executive, the judiciary. A fourth pillar has emerged called the media. In the minds of people today, for everything, we shall listen to what the court says. The government has to say that. The Supreme Court is what will decide. Politicians say it. People say it. Has the Supreme Court pushed itself in a position above the parliament, above the legislature? That is one aspect. And the other is just the name, Supreme Court of India. It is supreme amongst the courts of India. Article 141 says, law laid down by the Supreme Court shall be followed by all the courts of India. The Constitution does not say that the law laid down by the Supreme Court will necessarily be followed. That is an interpretation that flows from the Keshavanand Bharati case. So my question, sir, is, have we moved away after the Keshavanand Bharati case and the judgments subsequently also endorsing it, it's becoming a dogma, that the Supreme Court of India has become, from being the Supreme Court to the supreme institution of India, which now overrides Parliament and the will of the people?
I think Mr. Nanda has a problem there. The best part about the legal profession is that you are a free person. You are free to speak. Mr. Nanda, what is wrong with Keshavanand Bharati? What is wrong with the basic structure doctrine? Please tell me.
We have the preamble, sir, we the people of India. The book that Gogoi Sahab cited to you, my attention was drawn to that thanks to him. This book was written by the counsel for Advocate Sirvai. And Advocate Sirvai argued brilliantly, and his junior has written the book. Now, when a judgment says a certain thing cannot be altered, it amounts to saying that the generation of Indians who drafted the Constitution through the Constituent Assembly, and they represented, if Prahlad Rai Sahab is correct, the head of the law faculty who's done extensive work on this, it was about 10 to 15% of the Indian electorate which voted for the provincial assemblies in 46, which led to the indirect election and the Constituent Assembly. So you have a situation where 10% of the electorate voted, a constitution was drafted through that assembly. After that, today's parliament is much more representative. And when you say that some lines written by a certain generation shall never be altered, it amounts to saying, as Sirvai's eminent lawyer said, the dead shall rule from the grave, and they shall constrain the progress of India. So that is my problem. Angrily put, but that is it.
Mr. Nanda, if there is a problem with Keshavananda Bharati and the basic structure, society will throw it out. What is permanent? Tell me, what is permanent? Life itself is not permanent. Can anything be permanent? 200 years back, this is not the dress that we wore in India. Today we do. Why? Society has thrown it out, has brought this. Keshavananda Bharati, what is the quarrel? Constitution, संविधान के जो core principles है, ये रहेगा. This is Keshavananda Bharati, about 5,000 pages. 13 judges ने 13 judgment लिखा है. About 5,000 pages. Core is this, संविधान के जो core principles है वो बदल नहीं सकते, पार्लियामेंट बदल नहीं सकते. संविधान का core principles क्या है? डेमोक्रेसी. आप चाहते हैं कि डेमोक्रेसी चेंज हो जाए, डिक्टेटरशिप आए? कोई नहीं चाहेगा. इंडिपेंडेंस ऑफ जुडिशरी, जुडिशरी मस्ट बी इंडिपेंडेंट. ये जो कोर प्रिंसिपल्स है, इसमें 2-4 ऐसे प्रिंसिपल्स आ गए हैं शायद विच आर नॉट कोर प्रिंसिपल्स by later judgments. So the problem is not with Keshavanand Bharati. The problem is how long that list of basic structure is. Core principles कितने हैं? 3, 5, 10. ये list लंबा होते जा रहा है. The problem is there. The problem is not with the thinking. कि हमारे संविधान में ऐसे प्रिंसिपल्स हैं जो पार्लियामेंट बदल नहीं सकते. Yes, Mr. Nanda. So it's not a question of the judiciary being above the parliament, parliament being below the judiciary. नहीं है ऐसा. मैं जुडिशरी में भी था, मैं पार्लियामेंट में भी हूँ. ऐसा नहीं है. ऐसा सोचना भी, I don't think it's correct to think of that way. There is no superiority of one organ or one institution over the other.
That's, as judges would say, a matter of opinion. Another point, sir.
The judges say matter of opinion, but it is the judge's opinion which matters. Right.
Now, the judge's opinion matters in the...
Not retired judges.
The judge's opinion matters in the Supreme Court and through that in the other courts, and that's the limitation. It doesn't matter in the courts of the people, because people can change the Samvidhan also and make the judges do things differently.
Mr. Nanda, what is this people concept? What is this? May I ask a question? I have a bad habit again. I asked the other person a question. He is supposed to ask me, but I ask him. What is this people? बताइए. What is this people's will? क्या है? कहाँ पे? Where? Is there a provision in a constitution for referendum? Does parliament represent the will of the people? Theoretically, yes. What is parliament? What is people's will in parliament? Majority of the members of parliament belonging to the ruling party, whichever that party may be. Is that the people's will? So let us not bring in the people's will. Let us talk about parliamentary practices.
This book that Gogoi Sahab referred to, I'd heard of it vaguely, but Gogoi Sahab told me ये पढ़ने लायक है. And thanks to him, I have been able to read the book. And more arguments that emerge from this very book itself, sir. The will of the people is as nebulous a concept as justice, truth, liberty. For each of the words, fair play, reasonableness. What does fair play mean? What does natural justice mean? What does people mean? What do judges mean? What does law mean? What does justice mean? Law may mean a statute. Justice may mean an ethical element. So, sir, and if people doesn't mean anything, then I'm left asking, what does the first 3 words of the Constitution mean? We the people. Who has arrogated to speak on behalf of the people? The members elected in the Constituent Assembly. Now, I'm pointing to the larger dangers for democracy. Judiciary is supposed to be strengthening democracy. But we have a system where judges constitutionally were stated to be appointed by the president in consultation, etc., that consultation was interpreted as concurrence, a lay person would feel, well, consultation and concurrence is somewhat different. After concurrence, it was the judiciary which arrived at an interpretation that the names could be recommended by a collegium, then collegium ka baat would be concurrence, and if the government doesn't accept. So ultimately you've got a situation where an unelected, competent set of people, many of them Harvard and Cambridge educated, are judges. They are interpreting the law for you. Then they appoint from amongst themselves people who they think are people of great intellectual caliber as judges and so on, to interpret what the people in the parliament elected by them do. Now, this kind of along with that, as Justice Gogoi said, what is important is the list of subjects included as part of the constitution that cannot be changed. So if we keep expanding the list of subjects on which the elected representatives cannot make any amends, and if we keep fortifying the structure of the judiciary, we are moving in a direction of judiciary actually either hijacking the democracy or encroaching on the domain of people represented by the parliament, sir. That is a concern. I don't know whether it means anything or not.
Mr. Nanda, you have a point. You have a point. But I'll answer this dilemma in a little different way. See, Mr. Nanda, can you pinpoint any particular change or innovation that Parliament wanted to bring to enhance the spirit of the Constitution, which the judiciary prevented? Judiciary has it created an obstacle?
This is a very gray area, sir, on which a lot of us keep having discussions and thoughts. Now, coming to a very recent instance, Samvidhan Constitution reflects certain ideas of the people. Now, we know as part of this very many legal, when you look at the copy of the Samvidhan, it's an inverted kind of a triangle that you see, the original copy, and that has the national logo, Ashok Chakra and all, and uske niche likha hua hai Satyamev Jayate. If you look at the original copy of the Samvidhan in Parliament, our Constitution's original is not a printed one. It is very nicely calligraphed and handwritten one. And that has pictures and so on. We all know that principles of jurisprudence, law of evidence, etc., say that when you look at a document, you have to look at the document in its entirety. And symbols, graphics, etc. also communicate something that is evidence in law. Now, the framers of the Constitution, we adopted a logo which says Satyamev Jayate. The logo of the Supreme Court, sir, one second, the logo of the Supreme Court says Yato Dharmastito Jaya. What does Yato Dharmastita Jaya mean? It means where there is righteous conduct, the victory should be. That is the logo of the Supreme Court, sir. My concern is that the quest of Indian civilization has not perhaps really been God but truth, and if truth leads to God, so be it. So if truth is an important point to be reached, truth about my forefathers, my history is important. Truth about who I am, who we are as a society, what are our values, all that is important. Now, when under the grandiose label of what is a basic structure, some judge writes anonymously in a judgment no individual person can own, and says that inquiry on such and such matters of public interest shall be closed and done with and dusted as on the date of 15th August 1947. Now, the Ayodhya judgment, as the lawyers would know, you of course are among the authors, is talking about a dispute and that dispute is being addressed by the Supreme Court towards the end of the second decade of the 20th century, of the 21st century. And this Act of the Parliament is of 1991, sir, if I'm correct. Now, the Act of the Parliament itself excludes Ayodhya from consideration. There is a unanimity about that, even in the political discourse. So, as Justice Gogoi himself rightly indicated, and we had a minor chat on that, that ought to have been excluded from the reference of the Ayodhya judgment. It was not required to be decided, but some people felt that that should be mentioned as part of the basic structure. Now, the 91 Places of Worship Act has been mentioned as part of the basic structure in a judgment which was not primarily even looking at that subject. And now that is what the Supreme Court is now debating, the entire country is debating. So these kind of things perhaps do lead to a very confusing kind of a discourse amongst the country and wastage of people's energies also, sir, my submission.
What is life without confusion? The more the confusion, the more the solutions. Now, Mr. Nanda seems to have a little grouse against Harvard and Oxford returned lawyers becoming judges. He feels that, Harvard and Oxford returnees are incompetent or unable to feel the pulse of the Indian population. Now, I would not start with any such negative proposition, Mr. Nanda. Harvard, Oxford, these are training grounds of disciplining the mind. These are not branded products. Education, universities, these are all training grounds for disciplining the mind. So whether you are disciplined in Jodhpur or Jaipur or Harvard, I don't think it makes a difference. It's the mind, how it works. If you are sensitive, you are sensitive. If you are insensitive, regardless of where you have got your training, you are insensitive.
Now,
one minute, Mr. Nanda. See, what the judiciary wants is people with sensitive minds, people with commitment, people with a mission, with a zeal, people with a sense of fairness. There is one, I'm reminded of a gentleman, Shiv Khera. I believe he goes around creating positive feelings and encouraging people to be a success in life. And he's a very highly sought after speaker. When I was in Punjab, Shiv Khera came and he lectured for about 45 minutes. And then he asked me, the chief, what do you think? I said, look, I think I'll sum up your arguments in 2 words. The essence of life, the essence of judgeship. Be fair. When you are fair, you know that you are fair, and when you are being unfair, you know when you are being unfair. That each one of us know. And that is the sensitivity of a judge. Be fair. The chair of a judge is not to create anything. You're not running a popularity contest. You're not creating an electorate. You're not creating a base. You're dispensing justice. And as Mr. Nanda said, this is a very elusive concept. Justice, kya hai ye? Nothing. Justice is very simple. Be fair. Be fair. Jisko jo dena hai, jo hak hai, de do. That's all. So, whether you are trained in Harvard or in Jaipur or in Guwahati or in some small place in Assam, this sense of fairness is what comes to you as a human. And this sense of fairness, if it is missing in society, you have problems. And in today's society, you have it missing. Because the emphasis, as I said, is not on the family. The family is the breeding place for all this. The family life in most of the countries, including India, India is much better off, is gone. Everything is, look at our constitution. All, oriented towards individual rights, fundamental rights, legal rights, the protection of the individual. What about society? What about the family? It's easy to find fault with the laws, the constitution, and whatnot. But life evolves. Life keeps on evolving. And whether it's good law or bad law, that's what society decides. And through and getting the pulse of the society's opinion, it's the members, the elected members who decide. Yes, Mr.
Sir, among the major challenges, or the ones that are talked about that you handle the issues both as a Chief Justice, and one was the question of a lot of confusion about what was your response in handling the case about the petition about Kashmir after the obviating of the Article 370. And interestingly, the media reported that Justice Gogoi has no time for Kashmir. I would like you to, in your voice, respond as to what you said in the book, actually.
I don't know why the media said it. I love going to Kashmir. Every opportunity, every chance I get, I go to Kashmir. Why would Justice Gogoi not have time for Kashmir? I mean, But Mr. Nanda, I have dealt with all this in my book. Perhaps you have read it.
Yes, yes.
Right. I said public discourse. This is what is public discourse, the media. The media says Justice Gogoi does not have time for Kashmir because I was doing the Ayodhya matter. Maybe they didn't want me to do the Ayodhya matter. But they forget that on the same day, as the Chief Justice, I assigned the Kashmir cases to another bench to be heard on the day after. This they don't report. छोड़िए मिस्टर नंदा, ये मीडिया को मत लाइए.
No, हम सर मीडिया को छोड़ेंगे नहीं.
मत लाइए.
Now
I have seen media. Like every social entity, there is good media, there is bad media. There are good judges, there are bad judges, there are good lawyers, there are bad lawyers, there are good doctors, bad doctors. Right? Be magnanimous. बोल दिया क्या है? I have dealt with all these issues in my book. Why you want to repeat? पढ़ो आप.
I brought it to the attention of the people so that they are interested in the book, and I wanted to talk about the media also a little bit, because media, when it talks about law, creates information and disinformation both. And one of the issues on which disinformation has been created both by media and the politicians, and that is slightly germane. When the Ayodhya judgment came from the High Court, BJP leader Advani ji said that जनता की आस्था का सम्मान हुआ है. Others said कि आस्था के ऊपर फैसला तो नहीं हो सकता कोर्ट का. हम छोटा मोटा इधर लॉ का इश्यूज पढ़ रहे थे, समझ रहे थे कोर्ट्स में. एक छोटा सा एप्लीकेशन भी मुंसिफ मैजिस्ट्रेट डिसाइड करते हैं तो रीजनिंग देते हैं. सो इतना बड़ा फैसला हो गया, 3 जज बेंच ने कर दिया, एविडेंस नहीं देखा. They have not even looked at the evidence. That was the allegation by media and a whole lot of 64 odd intellectuals, historians writing that. And when you start looking at the judgment, it runs into 10,000 pages of the court copies, and it may take 3-4 months to read. It is evidence, evidence, and evidence. And it is full of evidence from non-Hindu, non-Muslim sources, which I'm sure you've had to look at as part of deciding the final appeal. Now, what is the way out when there is so much of misinformation happening? Do citizens have to take more interest in following and scrutinizing things, sir?
I will answer your doubts in this manner. It's been 2.5 years since I have retired. Has the media asked why in these 2.5 years the Kashmir cases have not been heard? Gogoi has no time for Kashmir. What about 2.5 years? The media doesn't ask that question. Why? My advice to the younger generation who's present here, who's saying what, don't be influenced by it. If you start paying attention to who's saying what, you had it. You will not be able to perform. Do whatever you are required to do in the best traditions of the office with your conscience clean. That's the only way. Forget about which newspaper is saying what and what channels is saying what. I have seen all of them.
साथ में चर्चा के लिए धन्यवाद श्री गोगोई साहब, श्री नंदा साहब।